Namaskar. This is Sridhar Joshi. You are watching the video channel Disciplinary Proceedings. Friends, in a democratic country like India, the administration has a very important, crucial role to play. Because every 5 years, elections are held and governments are formed. The governments may be of different parties, and therefore continuity is maintained only through administration. And therefore, it is necessary that a protection is provided to civil servants against the whims and fancies of the superiors and the politicians. And therefore, the framers of the Indian Constitution have deliberately provided such protection under Article 311 of the Constitution. In today's video, we are going to discuss the provisions of Article 311. Let us see what are those provisions. Now, the Article 311, 1 says, no person who is a member of a civil service of the Union or an All India service or a civil service of a state or both holding a civil post under the Union or state shall be dismissed or removed by an authority subordinate to that by which he was appointed. What 311(1) says? In short, no civil servant, he may be either of central or of the state, or he may be belonging to a service or holding a civil post, cannot be dismissed or removed by an authority lower than the authority which appointed him. Now, who is a civil servant? A civil servant is one whose pay and allowances are paid under the civil budget estimates from the fund of Consolidated Fund of India. Now, there are a number of services. For instance, All India Services, Central Civil Service, Central Health Services. Now, a member belonging to such service or a person may not be belonging to a specific service, but if he is holding a civil post, he cannot be dismissed or removed by an authority lower than the authority which appointed him. Now, one must understand what is the difference between dismissal and removal. What is dismissal and what is removal? Now, there are 2 points of difference between the dismissal and removal. In both cases, employee is terminated. But when a person is dismissed, it acts as a disqualification for future employment in the government. In short, a person who is dismissed will not be entitled to get a job in a government service. While in case of removal, that doesn't act as a disqualification. If a person is removed, he will be entitled. He can opt or he can apply for a government job. And if he is selected, he can be appointed on a government job. This is one point of difference. Now, another point of difference is a person who is dismissed is not entitled for pensionary benefits like pension and gratuity, which are available under the CCS pension rules or 11 pension rules. While in case a person who is removed, a compassionate pension can be given to him under the provisions of CCS pension rules. So that is what is the difference between dismissal and removal. Many times people confuse between the suspension and the dismissal and the removal. Now, what suspension is different. In case of a suspension of an employee is kept away from his job, away from his employment. He is not allowed to do the work. He is not given the salary. Instead of that, he is given the subsistence allowance. While in case of dismissal, naturally, if a person is dismissed or removed, question of payment of pay, allowances or any allowance doesn't arise to him. Now let us go to Article 311 in bracket 2 of the Constitution. In fact, this is the basis of the entire disciplinary proceedings or all the disciplinary proceedings, maybe CCA rules, 1965. What does Rule Article 311(2) says? No such person means no civil servant or a member belonging to civil service, shall be dismissed or removed or reduced in a rank except after an inquiry in which he has been informed of the charges against him and has been given a reasonable opportunity of being heard in respect of the charges. In short, no punishment of dismissal or removal or reduction in rank, that is reversion, can be inflicted, can be imposed against a government employee unless a department inquiry is held as per the rules, in which the charges against him are explained to him and he is given a reasonable opportunity of being heard in respect of the charges, and then only the punishment can be. Now we will be discussing in the later videos exactly what is the procedure which is required to be updated, etc. Now, reasonable opportunity. Now, what is reasonable opportunity is not explained in anywhere in this article or nowhere in the Constitution. We'll see what is that reasonable opportunity. It has been explained. This concept of reasonable opportunity has been explained by the Supreme Court in one of the judgments that we will discuss it later on. But in fact, Article 311(2) provides natural justice to an employee. As per principles of natural justice, no one can be held guilty unless heard. You can't hold a person guilty unless he is heard, unless allegations against him are explained to him and he is heard what he has to say about those charges. Are they acceptable to him? Are they not acceptable? Now, if such opportunity is not given, that will be violation of principle of natural justice. Similarly, what is natural justice in respect of disciplinary proceedings, etc., has been explained by the Supreme Court in a famous case of State Bank of Patiala versus S.K. Sharma. I will be discussing about those judgments later on. Today we are seeing only what are the provisions in the Article 311. Now, after having seen the provision under Article 302, let us go to, there are two provisos to Article 311. Now, the first proviso says, when after an inquiry, if a punishment is required to be imposed against the employee, no further opportunity is required to be given to him and to obtain his say. Once an inquiry is held, as per rules, according to natural, he has been given the due opportunity and a reasonable opportunity. And after holding the inquiry, if the disciplinary authority or the appointing authority comes to conclusion that this is a case in which certain penalty is required to be imposed, there is no necessity of giving a further opportunity to the employee to obtain his say or to give his say on the penalty which is being proposed. Now, this provision has been added in 1972 by an amendment. But still, it is always seen that disciplinary authorities, after completion of inquiry, gives one more opportunity to the employee and ask his say on the proposed penalty. This opportunity is not required. By giving such opportunity, the department inquiries are delayed and no final decision is taken. This is first provision. Now, there is a second provision which is very important, that this clause means the clause under 311(2) is not applicable in certain cases, in certain circumstances. What are those circumstances? Where a person is dismissed or removed or reduced in a rank on the ground of conduct which has led to his conviction on a criminal charge. If an employee is held guilty by a criminal court for a criminal offense which is punishable under Indian Penal Code or some appropriate penal law, and because of his conviction, if his person is dismissed or removed or reduced in a rank, no inquiry is required to be held. Because the inquiry has been already been held by a criminal court. The employee has been given an opportunity to give whatever he said, etc. And therefore, there is no necessity for holding another department inquiry and before imposing such punishment. So this is first. Now, second circumstances is where the authority empowered to dismiss or remove or reduce in rank is convinced for some reasons to be recorded in writing that it is not reasonably practicable to conduct the inquiry. Now, there are certain circumstances where it is not practicable to hold in the inquiry. For instance, that employee is not found. The police have reported that for last 7 years he is absconding and his whereabouts are not known. Naturally, in such circumstances, no inquiry can be held. And it is not reasonably practicable to conduct an inquiry. And therefore, in such circumstances, without conducting an inquiry, such employee can be dismissed or removed or reduced in a rank. Or for example, if an employee is very arrogant, when he appears before the inquiry officer, he shouts, he puts his fist on the table, etc., and doesn't allow the inquiry officer to conduct an inquiry. Now, in such inquiry, in circumstances also, it is not reasonably practicable to conduct inquiry. Now, in such circumstances, the disciplinary authority has to record the reasons why it is not practicable to conduct an inquiry first and then pass an order of imposing a penalty of dismissal, removal or reduction in rank or any other penalty. So this is the second circumstance. No department inquiry is necessary. And in the third circumstances, if the president or the governor, as the case may be, is satisfied that it is not in the interest of the security of the state to conduct an inquiry. Now, when the governor or a president, in case of central government employee, naturally it will be present. If he is satisfied that it is not in the interest of the security of the union to hold an inquiry against a particular employee, that employee can be dismissed, removed or reduced at rank, or any penalty can be imposed against him without conducting an inquiry. So in short, there are three circumstances in which it is not necessary to conduct a department inquiry and punishment can be imposed without conducting such inquiry. The first circumstance is where a penalty is being imposed against an employee for his conviction by a criminal court on the ground of a criminal offense committed by him. First circumstance. Second, when it is not reasonably practicable to conduct an inquiry, in such inquiry circumstances also, without conducting an inquiry, in department inquiry, punishment can be imposed. Third, when the president or the governor, as the case may be, is convinced that it is not in the interest of the security of the state to conduct a department inquiry against a specific employee. Now, in circumstances also, no departmental inquiry is required. Now, there is a third clause, 311.3. The question, who will decide what is reasonably practicable to conduct inquiry or not? The clause 311.3 of the article 311 says, if in respect of such person, a question arises whether it is reasonably practicable to conduct or hold inquiry, the decision thereon of the authority empowered to dismiss or remove or such person or to reduce him rank shall be final. So, whenever there is a question whether it is reasonably practicable to conduct an inquiry or not, the decision of the authority, that means who is empowered to dismiss, remove and reduce in rank. Obviously, it is then appointing authority. If it is satisfied that it is not reasonably practicable to conduct an inquiry, such authority will have to record the reasons in writing and then impose the punishment. Friends, these are the provisions of Article 311. We will have to see exactly in detail. There are 3 concepts which are involved under 311 of the article of the Constitution. Number one, what is natural justice? What is reasonably practical? What are the implications of Article 311? And when the provisions of Article 311 apply, in respect of which category of employees they apply. We'll discuss all these issues in the next video in the next week. Thank you. Namaskar.